Go ahead. Good afternoon, Mr. Arbitrator. My name is Seah, and I'll be speaking on behalf of the first appellant, Mr. Landed, on the first issue regarding GDC's quorum and the fourth issue on doping for 15 minutes. My co-counsel, Mr. Mark Maxwell Peter, will be speaking on behalf of the second appellant, Ms. Tangs, and he will address issues 2 on the location of the tribunal and issue 3 on Ms. Tang's admissibility for 14 minutes. We respectfully reserve 1 minute for a rebuttal. Mr. Arbitrator, this case is about removing the taint of illegality and discrimination so that justice can be done. The gold medal is Mr. Landet's, not as an indulgence, but as a matter of right. He secured it on the field of play, driving his team's comeback in the finals of the qualifying games. And yet, he faced a tribunal whose majority was inherently biased to Ms. Tangs. In these circumstances, the law requires its return. To deny him would be a miscarriage of justice, which erodes the very notions of protections athletes are entitled to. With that, I make 2 submissions regarding the first and fourth issue. Firstly, the Games Disciplinary Committee, hereinafter the GDC, was biased in coming to a decision. Mr. Douglas and Ms. Farina are not independent and impartial arbitrators of the GDC's quorum. Secondly, the GDC had erred in finding that Mr. Landed had been liable for doping. Blue Bat is not inside the World Anti-Doping List, and Mr. Landed is hence not liable for doping. Turning to the first issue, to determine the criteria of an arbitrator, the applicable rule is that from Rule 33 from the Court of Sport related arbitration, hereinafter the CES Code. Rule 33 states, and I quote, "Every arbitrator shall be and remain impartial and independent of the parties and shall immediately disclose any circumstances which may affect her or his independence with respect to the parties." This similar wording can be found in Malaysia's Arbitration Act under Section 13(8) Part B. As noted in the wording of Rule 33, the criteria of an arbitrator requires both impartiality and independence. As long as one of these criteria are not met, this would demonstrate that an arbitrator is biased. Firstly, we argue that there was a lack of independence on both parts of Ms. Farina and Mr. Douglas. To determine what amounts to an independent arbitrator, we can look to case law. In the CES 2006 of FCV and FCS, at paragraph 5, it noted that strong or negative emotional bonds through relations between an arbitrator and one party may indicate a lack of independence. This proposition was similarly held in the 2007 Swiss Federal Tribunal case of Sunday Center Constructions at paragraph 3. Turning to our case, Ms. Farina, first to Ms. Farina, there are 2 types of relationships that she has with Ms. Tangs. At para 4 of the record, she's Ms. Tang's cousin sister, showing that Ms. Farina has a familial relationship with Ms. Tangs. Essentially, Ms. Tangs is Ms. Farina's cousin, showing a personal relationship between both parties. This kind of personal connection could easily be characterized as a strong emotional bond between family members, which can indicate a lack of impartiality on the part of an arbitrator. At para 4 of the record, Ms. Farina also provided extra on-the-side coaching to Ms. Tangs and prepared them for the upcoming qualifying games. This demonstrates a professional relationship where Ms. Farina had invested time and effort into Ms. Tang's success prior to adjudicating on a dispute involving her. With both a professional and personal relationship, it can be inferred that Ms. Farina and Ms. Tangs possess a strong emotional bond. Turning next to Mr. Douglas, as seen at para 26 of the record, 6 months prior to the event of the case, he was engaged to have a one-time special and personal sharing session for Ms. Tang's team. This shows professional support for Ms. Tang's team. Following the session, in that very same paragraph of the record, their relationship eventually got closer, with both parties being in contact since. This ongoing and close personal relationship constitutes a continuing positive bond extending beyond a single positive engagement. This is further bolstered by the fact that Mr. Douglas had participated with Ms. Tanks in fan meetups. Going beyond a simple role as a coach, this public association further solidifies the factual existence of a positive and strong bond that lasted for the 6 months till the very date of the hearing. Furthermore, even though the Mr. Arbitrator may not be with me at this point, there's still a lack of impartiality on both parts of Ms. Farina and Mr. Douglas. In fact, there does not need to be an actual finding of impartiality. Rather, it suffices that an arbitrator, based on the circumstances relating to the arbitration, to be objectively viewed as such. This proposition was laid out at paragraph 7.4 in a 2020 Swiss Federal Tribunal case of Zhang and World Anti-Doping Agency. This proposition is further supported by the IBA guidelines on conflicts of interest in international arbitration at section 2B, where the relevant portion reads, and I quote, "From the point of view of a reasonable third person having knowledge of the relevant facts and the circumstances that would give rise to doubts as to the arbitrator's impartiality or independence." While it's noted that such guidelines are not binding, such guidelines will still have an impactful influence on the practice of arbitration in such an institution or court. In our case, we acknowledge that there's no evidence of any actual bias demonstrated by either Mr. Douglas or Ms. Farina. However, the necessary inference is that there's biasness arising from the objective reasonable third party. As seen from para 26 of the record, the quorum is a tribunal operating with a two-third majority, maintaining documented personal, familial, and professional bonds with Ms. Tanks, the party contesting the results. They cannot objectively be viewed as independent in its adverse ruling against Mr. Landert, as seen at para 33 of the record. Simply put, the presence of a familiar relationship between Ms. Tanks and Ms. Farina, coupled with a close extended personal relationship between Mr. Douglas and Ms. Tanks, is sufficient for a reasonable third party to ascertain their lack of independence. In conclusion, we submit that Ms. Farina and Mr. Douglas are biased members of the GDC's quorum. And now, I'll turn to the second issue regarding Mr. Landert's doping violation. Our submission are structured into three main arguments. Firstly, Rule 12 of the qualifying game rules should not be applied, as it is overly broad and inconsistent with the WADA code, and a finding of a doping violation under the GDC's own rules is unfounded. Bluebat is not a prohibited substance under the WADA code, and liability cannot attach to unlisted substances. Thirdly and lastly, the GDC's enforcement of its anti-doping rules violated the principles of legality, due process, and legitimate expectation due to the lack of clear notice. Turning to our first main argument, the WADA code should be the exclusive standard for doping violations. While the appellant seeks to rely on Rule 12 of the QGR to find that Mr. Landert, while the respondent may seek to rely on Rule 12 of the qualifying game rules to find that Mr. Landert had committed a doping violation, reliance on Rule 12 is wrong. Rule 7 to 13 of the qualifying game rules clearly provide that doping is defined by reference to the WADA code and the prohibited list. Rule 7 defines doping as the occurrence of violations set forth in the WADA prohibited list and the WADA code. Rule 13 instructs athletes to refer to the WADA prohibited list for the list of prohibited substances. Accordingly, the WADA code forms the exclusive and mandatory benchmark for determining anti-doping violations, which mirrors the structure of Olympic Charter Rule 44, which makes adherence to the WADA code obligatory for the IOC. Secondly, in the same vein, Rule 12 is inconsistent and ultra-virus. Quoting Rule 12 defines a prohibited substance as any substance or method contrary to the spirit of the sport. This is clearly a broad definition that a court of sport or for arbitration has rejected. In the 2007-2004 CES case of Maria Louise Kelly Williams, the panel noted that a catch-all provision of other chemical substances with similar chemical structure cannot be construed to mean every stimulant, which is precisely what Rule 12 of the qualifying games seek to do. At paragraph 25, it was noted that such an interpretation would not pass the test of clarity and predictability. They further brought examples of other stimulants such as nicotine and caffeine, which all fall under the interpretation of Rule 12, and yet are not banned by the CAS. Therefore, an extremely restrictive approach must be taken into interpreting Rule 12, which should be read together with the WADA guidelines, which is precisely what Rule 13 of the qualifying game rules has noted. Therefore, Rule 12 must be read restrictively and in harmony with Rule 7 and 13. Furthermore, CAS jurisprudence confirms that sporting bodies cannot expand doping rules. In the 2011 CAS case of USOC and the International Olympic Council, known as the Osaka Rule case, the IOC's attempt to impose additional sanctions beyond the WADA code was held invalid because the Olympic Charter had already made the code mandatory. Therefore, Rule 12 of the QGR should not be followed, and a finding of a doping violation under GDC's own rules is ultra-virus. Turning to our second main argument, bluebet is not a prohibited substance under the WADA code. Firstly, liability only arises for listed substances, and this has been a constantly applied rule by the CAS jurisprudence. In the 2006 CAS case of Putera and ITF, at paragraph 49, it noted that strict liabilities applies only to listed substances, and if a substance is unlisted, liability cannot attach. However, we note that liability can attach to unlisted substances, but only in exceptional circumstances. Quoting again the 2004 CAS case of Maria Louise Kelly Williams and IOC, the athlete had took neosaldina, which contained isometapine. Although considered a stimulant, isometapine was not listed in the WADA prohibited list. The panel held that an unlisted substance may only be banned if it has a similar chemical structure or pharmacological effect to a listed stimulant. In our case, although bluebet may not be considered a stimulant, it likely does not have a similar chemical structure known to any prohibited substances. As seen from para 30 of the record, Mr. Lander's medical team had researched bluebet, and yet they were still uncertain about the product's status. Presently, we do not have enough facts to determine if bluebet indeed bears similar chemical structure or pharmacological effects to unlisted substances. Notably, in Ms. Williams' case, although isometapine was initially considered to be a stimulant, subsequent detailed medical research did find that it was not considered to be a prohibited substance. Therefore, it would be presumptuous of the court to jump the gun and find that Mr. Lander had breached the WADA code without further examining the precise chemical nature of bluebet. Therefore, the GDC had erred in finding that Mr. Lander committed a doping violation. Unless I may be of further assistance to the council. This concludes my submission, and I'll turn my time over to Mr. Mark Maxwell Peter, who will address you on the remaining issues. Thank you.
Thank you, Austin. Mr. President, members of the tribunal, my name is Mark, appearing for the appellant, Ms. Tanks. I will address two issues in this hearing. The first concerns whether the GDC erred in convening the disciplinary tribunal at South Nangkailan. I will speak for 14 minutes on both the issues and reserve 1 minute for rebuttal. Mr. President, I will structure my submissions in two parts. First, the legal framework, namely the Malaysian Arbitration Act 2005 and the qualifying game rules. And secondly, the relevant authorities and how they apply to the record before this tribunal to demonstrate why the tribunal held in South Nangkailan cannot stand. The governing law of this arbitration is Malaysian law, as clarified at paragraph 42 of the clarification notes. The Section 2 of the Arbitration Act provides, and I quote, where the parties fail to agree, the seat shall be determined having regard to the circumstances of the case, including the convenience of the parties. This embodies the principle of procedural fairness that the chosen venue must not prejudice either side. In addition, Rule 23, subsection 1 of the qualifying game rules require that an internal tribunal be convened in a country where the tournament was held, where reasonably practicable. That safeguard ensures hearing occurs near the competition site in an environment equally accessible to all the participants. As the record shows at paragraph 29, the riots in Rambutana subsided within 3 days, and the tribunal was established 1 week later. It was therefore practicable to hold a hearing in Rambutan itself, as the rules require, and by relocating the tribunal to South Nagaland, which houses the Federation's administrative office, the GDC disregarded both Section 22 of the Malaysian Act and Rule 22 of the Qualifying Rule Games. The interpretation aligns with the Federal Court decision of R. Ramachandra and Industrial Court of Malaysia, paragraph 1, where the courts held that the decision tainted by procedural unfairness or bias is invalid. Accordingly, the GDC relocation of the tribunal contravened not only the domestic legal framework, but also the overarching principles of lex sportiva, which demands that the disciplinary bodies act impartially and avoid even the appearance of home court advantage. Mr. President, in the 2018 case of Muthu Peshin and Switzerland, from paragraph 139 to 143, the courts explicitly explained that the impartiality must satisfy both a subjective and objective test, namely whether a reasonable observer would perceive the tribunal as independent. Applying these principles here, the seating of the tribunal in South Nagaland creates an appearance of impartiality, namely because the GDC is institutionally tied with the organizing structure of the global games. The local law, the administrative staff, and the facility also belongs to the same federation, overseeing the disciplinary process. And lastly, the procedural familiarity and logistical advantages over the respondent, placing the athletes at disadvantage. Furthermore, in Muthu and Peshin case, where the athletes who went through the CS proceedings applying under the Article 6, subsection 1, finally, in Ali Reza and Turkish Football Federation, paragraph 212 and 216, the principle was made explicit. Justice must not only be done, but also must seem to be done. Even though the appearance of the bias is fatal, the tribunal in South Nagaland fails the standard of apparent impartiality. And for these very reasons, the appellant respectfully submits that the GDC's internal tribunal was improperly convened in South Nagaland. We therefore ask the decision to be annulled and the matter remitted to the tribunal convened in a neutral form in accordance with the Malaysian Arbitration Act of 2005 and the principle of lex sportiva. Only a true neutral seat can guarantee the independence, transparency, and the fairness that the athletes are entitled under the international sporting law. Now, moving on to the second issue. The next issue relates to whether the GDC erred in declaring Ms. Tanks ineligible to participate in the qualifying games. And we submit that the GDC acted ultra vires and in the violation of both the qualifying game rules and lex sportiva. The GDC misinterpreted Rule 3 of the qualifying games rules, rewriting the standard of eligibility to require, I quote, 100% of Asian citizenship, thereby acting discriminatory and beyond its powers. Rule 3, subsection 1 provides that a person is eligible to be a participating athlete if he or she is a citizen or the permanent resident of a country in Asia. There is no mention of exclusive or 100% Asian citizenship by its By its plain meaning, the rules adopt an inclusive standard based on the citizenship or residence, not a restrictive test of purity of nationality. Any attempts by GDC to narrow down this rule departs from the text and violates the principles of legality and fairness under lex sportiva. As the record shows on paragraph 33, subsection B, the GDC held that Ms. Tanks was not 100% Asian citizen and therefore ineligible to participate. However, that additional require does not exist in the rules. In doing so, the GDC exceeds an interpretive authority and powers and acted as a rule maker rather than a rule interpretator. In the 2000 CS case of ANS and Norwegian Wrestling Federation, paragraph 18, the panel held that the rules were ambiguous and they must be interpreted contra perforitum against the drafting body, which is usually the sporting federation. Similarly, in the 1991 case of G and FEI para 7, the panel reiterated that the unclear regulations must not prejudice the athlete who rely on the published text. Applying these principles any doubt in Rule 3 must be construed in the favor of athlete and not against her. Moreover, in the 2009 case of Telkom Egypt Club and Egyptian Football Federation, paragraph 33, the panel hold, and I quote, the CAS cannot rewrite, but only interpret rules set forth by the sports authority in the light of general principles of law. The GDC, by adding an unwritten requirement of sole nationality, effectively rewrote Rule 3 and therefore acted ultra-virus. The interpretation is supported by international sporting federations on dual nationality. In the 1994 case of Puerto Rico Amateur Football Federation and the US baseball team, paragraph 1 to 2, the panel affirmed that each country has a sovereign right to determine its own nationality and that the dual nation athletes may freely choose which country to represent, provided that they have not previously represented another nation. At page 9 of that award, the panel also stated that the athlete having dual nationality of US and Puerto Rico citizenship remained free to elect which one of the two countries he wished to play for, absent prior representation. This approach is consistent with the Rule 41 Bylaw 2 of the Olympic Charter, which expressly recognizes that the competitor who is a national of two or more nations may elect which country to represent. Lex Sportiva therefore safeguards the dual nationality autonomy in choosing representation, subject only to the formal citizenship recognized by the state. Now, by applying these authorities to the record, Ms. Tang satisfies every requirement of Rule 3, subsection 1. First, she is a citizen of Durrania, an Asian country. Second, she has resided there for 9 years. And third, she has never represented her birth country, Kyrgyzstan, an oceanic state. Her citizenship was validly conferred by Durrania sovereign law, and she submitted documentary proof of domicile as noted on paragraph 32 of the record. Under the case of PARBF and US Baseball Olympic Charter, she therefore had the right to elect and represent Durrania. The JDC's election to disregard her lawful citizenship and to demand 100% Asian origin was contrary to the Lex Sportiva and the principles of equality in sport. Finally, the GDC's the GDC's approach undermines the consistency and fairness that the 1998 case of AEK Athens and Slavia Prague at paragraph 19, which identifies as a fundamental to Lex Sportiva, the maintenance of the uniform and predictability of the standards across international sports. If dual citizens are excluded based on the undefined regional purity, the integrity and the exclusivity of the international competitions are seriously compromised. Mr. President, therefore, I would like to conclude my two arguments, which is, first, on the tribunal's constitution, the GDC's decision to contravene proceedings in South Nagaland, its headquarters, and undermine neutrality and procedural fairness, as held in Muthu and Peshin and Ali Raza, justice must not only be done, but must be seen to be done. And second, on the eligibility, the GDC exceeded its authority by rewriting Rule 3 to require 100% citizenship. The CAS jurisprudence in Telkom, Egypt, and PARBF makes it clear that the sporting bodies interpret rules, they don't invent them. Accordingly, we respectfully pray that this tribunal allows both the issues, and declare that the South Nagaland tribunal invalid and affirm Ms. Tang's eligibility, thereby restoring the fairness, neutrality, and integrity owed to all athletes. Unless I can assist further, Mr. President, I would like to defer to my written submissions and hand over the stage to Mr. Brandon Zhang. Thank you.
No, it's not kind of with the respondents. Okay.